again, everyone. This is Marc Movsesian. I'm the director of the Center for Law and Religion at St. John's University. I'm joined once more by my friend and colleague, Professor Marc DeGirolami, who's the center's associate director. And this is another episode of Legal Spirits, a podcast series on cases and issues in law and religion. You can listen to archived episodes at lawandreligionforum.org. That's one word, that's our website, or also on iTunes. Okay, Marc. Well, in today's episode, we're going to talk about an interesting oral argument that took place this week at the Supreme Court in a case called American Legion versus American Humanist Association. This is a case involving the so-called Peace Cross, which is a 93-year-old war memorial in Bladensburg, Maryland. A lower court, the Fourth Circuit, said that the cross violated the Establishment Clause, and that's what the Supreme Court was considering this week. So, Marc, you want to give us a rundown on the facts of the case, just a reminder for our listeners?
Sure. I'll be quick with them because in our previous podcast, we went into some excruciating detail with all of the facts. And if you want to know all of those excruciating details, you can either read the case or you can go back and listen to the old podcast, which, by the way, you should do. But the cross here is anywhere between 32 and 40-foot cross that sits on the median of a fairly busy highway in St. George's County and is part of a larger set of monuments, although those other monuments in this sort of monument park area are set at some distance from the cross. And so the question, the cross, as you mentioned, was erected to honor the memory of, I think it's 49 people from the county who died in World War I. The cross has various words on it and so on, as well as a plaque honoring, stating that it's honoring those folks. And so the question that the court is confronting is what to do about the cross. And as you say, it was actually quite a long argument with a number of different interveners and a number of different things that the justices said.
Yeah, Marc, it's interesting. This case shows once again the peculiar power of religious symbols to elicit emotion. It's gotten a great deal of attention among law professors and some rather heated commentary back and forth from law professors. I don't know how much the general public finds war memorials like this controversial. My sense is no, I could be wrong about that, but certainly within the legal academy, it's gotten a great deal of attention.
Yeah, and I think one thing to note is, the Roberts Court has kind of stayed away from these monument cases. There was a set of cases back in 2005 before the Roberts Court became the Roberts Court, actually, before Chief Justice Roberts was the Chief Justice, involving Ten Commandments displays. There have been the odd case about, for example, a cross in the desert that ended up not being resolved on Establishment Clause grounds. But by and large, and with just a couple of exceptions, the court has really stayed away from this kind of issue and talked about other things. It's talked about church associations and anti-discrimination laws and religious exemptions and so on, but not really this kind of issue. Unlike, for example, the Rehnquist Court and the Berger Court, which was more inclined to get involved in this kind of question.
Yeah, and we'll talk about some of those Rehnquist and Berger Court opinions too. So, well, Marc, what everybody wants to know, and I guess the first thing we should just say at the top of the podcast is, okay, what's going to happen in this case? I'm fairly confident, Marc. I don't know what you think. I'm fairly confident that the court is going to say this cross is constitutional. In fact, I suspect it won't even be a very close vote on that. However, I do think it's on. You and I may disagree about this. I'm not sure the court's going to use this case to come up with a categorical test, which is what some people were hoping or fearing. What do you think?
Yeah, I would agree with the first part of your statement. Certainly, I think that after argument, it does seem that the cross will probably stay. And the question, I'm not sure that it will be a unanimous decision that the cross should stay. But I think that either we're talking about a 6-3 or a 7-2 with respect to the final result of the cross staying. Of course, as you say, there are going to be the interesting part of this case is how it stays or the rationale that the court uses.
Yeah, well, let me explain to you and to our listeners why I say I don't think there's going to be a categorical test announced. And the reason although I agree with you again, I think it's going to be a lopsided vote in favor of the crosses remaining. It's just that when you look back at these earlier cases to which you were adverting before, from the Rehnquist Court and the Berger Court, and even some opinions from the Roberts Court, when you look at the court's opinions on public religious displays, it's a jurisprudence of themes, not rules. These cases tend to be very fact-specific. They turn on particular contexts. And I think you could say there are themes in the jurisprudence. For example, one key theme is the need for state religious neutrality. Sometimes the justices talk about a ban on proselytization by the state, a ban on coercion by the state. Sometimes the justices speak in terms of sectarian religious symbols are bad, but sectarian religious symbols with cultural meaning, well, they're okay. There are sometimes the justices say non-sectarian symbols are okay, like the Ten Commandments. There's a theme in the jurisprudence that long-standing monuments can stay, but not others. So if you look back at the history of the Supreme Court's cases here, it's hard to say that other than broad themes, they really stand for very much at all. And so I would guess going forward, the court's going to do the same thing. But I know, Marc, that you may disagree with that.
Well, look, I mean, I think that you make some very sound points. This has been the approach that the court has used really for the last 30 plus years when it comes to these religious symbols, beginning with Lynch versus Donnelly. Even though that one was upheld, there was the concurrence of Justice O'Connor adopting the endorsement test, and then in the county of Allegheny, and then in the Ten Commandments cases, both of them, McCreary and Van Orden, the court has kind of, limped along with this smorgasbord of approaches. And by the way, there's the Lemon versus Kurtzman test in the background here. There's the question about whether the smorgasbord of approaches, how it relates to the Lemon test. My own view is that it's a particular kind of gloss on the second component of the Lemon test, the requirement that there shouldn't be a primary effect of promoting religion when the government does whatever it does. And so I think you're quite right that if the court continues to kind of limp along in this way, in this sort of particularistic thematic way, then you're looking at possibly an opinion that adopts a Justice Breyer-like approach, the approach that Justice Breyer used in his very important concurrence in Van Orden versus Perry, where he was the fifth vote to uphold the Ten Commandments monument on the basis of, as you say, the monument's age and the fact that it had stood there for a long time without complaint, and the fact that it was surrounded by other monuments that are civic in character, and the fact that it was outside, and the fact that it was a certain distance, all of these little factual particulars. However, I would say that one does get the sense in reading this oral argument transcript that there was a certain frustration among some justices about just continuing along with that kind of approach. Chief Justice Roberts repeatedly talked about the need for something concise or crisp to offer lower courts. He mentioned that several times. Justice Gorsuch talked about the fact that, are we going to continue to keep Lemon around but not to apply it? Justice Kavanaugh said the same thing. Justice Alito even asked the lawyer for the people opposing the cross for the Humanist Association, should we have an opinion that just says this cross is super bad, it's especially bad, this one has to come down, but every other cross is fine, he asked. Would you like us to write that in an opinion? So I do think you're right. If the court goes with the approach that it has gone with, then you're looking at a narrow sort of perhaps Breyer-authored opinion. But it might decide, jurisprudence can change, and it might decide to go in a different direction.
Okay, could be. Well, I don't think that it's going to be a Breyer majority opinion for reasons we can talk about later. But let me give you another reason why I think this. It's not simply that you look at past history and you see what the court has done, but also it seems to me the Roberts Court likes minimalist decisions in this area that kind of keep the court out of the fray. I know some of our friends in the Academy will immediately disagree with how I've characterized this, but if you think of a case like Masterpiece Cake Shop, it was kind of a narrow decision. Even Hosanna Tabor was unanimous because it really was a kind of narrow decision on these things, it seems to me. And so they might want to do that here too. So here's one possibility I could think about based on the argument. Maybe what we have in this case is an opinion by someone, maybe Chief Justice Roberts, along these lines. this cross, the Bladensburg War Memorial, this is a traditional war memorial of the sort that is very clearly associated, especially with World War I, with what the attorney for the American Legion, Neil Katyal, called fields of Flanders and stuff. You know, the sort of thing, we're used to this kind of World War I memorial. It's traditional. It is not coercive, doesn't force anyone to do anything, and therefore it's likely to be constitutional. And in that same opinion, there will be a statement that says we're not going to consider whether other crosses, for example, that are not war memorials or that are put up more recently, we're just not going to consider those things. We'll reserve that for a different day. I think you could get maybe a majority opinion along those lines. Mark?
Sure, that might be the approach. And I think the people that oppose the cross would very much like that approach because they know they're going to lose. They know they're going to lose this case. We said at the beginning, it's not, other than perhaps Justice Sotomayor and Justice Ginsburg, the cross is going to stay. So the people that fear, that know that that's coming, are hoping for that kind of approach, an approach that combines, this is an old thing, it's associated with World War I, no non-Christians were objected to this or objected to being memorialized in this way, and therefore it's okay. It does seem to me that there was some spirit in the comments, from the Chief Justice, but especially from Justice Gorsuch and Justice Kavanaugh and even Justice Alito, that, and certainly I would think Justice Thomas feels this way, although he's a separate category altogether that we can talk about, that's not good enough anymore, that they would like to do something different. And that would, if they decide, if that wins the day, then maybe what you're looking at is a plurality opinion authored by one of those justices, and then a concurrence in the style that you've just described by Justice Breyer, possibly joined by Justice Kagan and or the Chief, depending on what he wants to do.
So I understand that. I mean, the beauty part of the what I'm describing, what would be the beauty part, is that you could get 7 votes, I think, for the opinion that I have just described. This is a traditional monument. It is, and I would add, in addition, it's not coercive, and we're just not going to address other possibilities. And then, and by the way, I agree with you. I think Justices Ginsburg and Sotomayor clearly are not going to join that. They seem to me very likely to stick with the endorsement test and say this cross is an endorsement of Christianity and therefore it violates the Establishment Clause, and they'll be on the side. But you could get 7 votes for a minimalist decision. And then in addition to that, then there might well be several separate concurrences. For example, I could see concurrences from Justices Alito, Gorsuch, and Kavanaugh doing just as you say, that say, okay, well, that's how we decide this case, but we want to go further. And we want to adopt some other categorical test that would settle more than just this one. And Mark, okay, what do you think that categorical test would be if they were to go that way?
Yeah, so let's think about that together. I think maybe the first carve-out that we can make is Justice Thomas, who has adopted this jurisdictional view of the Establishment Clause, which basically says, on his view, the Establishment Clause simply does not apply to the states. It's a federalism provision that was intended to protect state establishments, actually, at the founding, but certainly to keep the federal government out of this business. I agree
with you, Mark. I think he will be on his own. I think he'll just write, look, I don't think this is incorporated against the states, and he'll do his own concurrence in the judgment.
Here's a question. I don't know that this will happen, but it is possible at least that Justice Gorsuch would join him. Justice Gorsuch has indicated in a case just decided before this, Timms versus Indiana, that he's persuaded by the Justice Thomas view that the Privileges or Immunities Clause is the ground for incorporation, not the Due Process Clause. So that's a major revision. Justice Thomas has always been way out there on his own on this view. It's not necessarily to say that it's a wrong view, but it's certainly a particular view. And it might be that you get Justice Gorsuch for that view, but I don't think you would get anybody else for that position.
Yeah, and since you brought up Justice Gorsuch, I do want to also point out he actually asked some questions about standing and said, well, where is actually standing here? Because, so these people were offended. How is just taking offense at something enough to give you Standing, I think that might have been a deeper critique of the endorsement test, actually. But I guess he could write something on standing. Even Chief Justice Roberts seemed a little bit interested in that, but I don't know.
That's a possibility. When we had our podcast last time, I raised this as a possible way out. Again, that would be a narrow decision because it would say, look, on the facts of this particular case, taking offense when you're driving down the highway at a symbol that you don't like, that's not good enough. Of course, you might have a broader standing decision that says something like offensiveness in general is not sufficient to get standing in these symbolic or symbols cases. That seemed to be the kind of question, the kind of line of argument that Justice Gorsuch was arguing for. But so let's set that aside.
Right.
Yeah.
But let's say that Justice Gorsuch, Justice Kavanaugh, Justice Alito really do want to reach the merits here, and that they want to go beyond the minimalist decision that I've suggested. In the oral argument, there were a number of different tests raised, and what test do you think these justices would go for?
There are a number of possibilities, as you say correctly. There's a coercion test possibility. There's a test involving proselytization.
Yeah, they didn't seem to like that one too much, actually. I was surprised by that. I was surprised by how negative they were about that.
In fact, particularly Justice Gorsuch thought that, you could see this in his questioning, that he thought that a proselytization test would essentially get down to the same sorts of endorsement test problems that have from his perspective, plagued the court in these kinds of cases. And what really is the difference between proselytization and endorsement when you come right down to the factual particulars? Probably, I agree with this, probably not going to be the approach they use. Coercion is one approach. There was an approach proposed in the Beckett Fund brief, relying on some scholarship by Professor Michael McConnell, who is actually, as it happens, our keynote speaker for our first Tradition Project conference, who has emphasized a historical approach, which looks to several key interests that we have in the government, not creating establishments of religion, not that there not be a national church, and so on and so forth. On and on. He's got 6 different ones, and he has argued for sort of historical analogies. Maybe that will be the approach that they use. There's a sort of spin on that approach, which looks to traditional practices, the town of Greece approach, which would say, look, the question here is about whether the practice of sponsoring these symbols goes back to the founding and even before, and you can trace its kind of consistency throughout. That's another possibility. So there are a number of options that the court has. One difficulty, of course, is that if the court goes with one of these, particularly coercion, there might be some problems with other sorts of, that is to say, if they go with coercion as a categorical test for all Establishment Clause issues, there might be some kinds of things that aren't captured by that kind of approach. So I don't expect that to happen. And then finally, I would say, if this is the way that the court goes, there's the question of what happens to Lemon versus Kurtzman, right? So if they adopt a new approach, do they adopt it while overruling Lemon? Do they adopt it while overruling a part of Lemon? Do they leave part of Lemon in place and keep other parts, or throw out other parts, or just limit the scope of Lemon, particularly that troublesome second primary effects factor? All of those are on the table, it seems to me.
Yeah, I think, Mark, I think you might get, for these justices, and maybe, for these justices, the ones I'm thinking of, Alito, Gorsuch, Kavanaugh, maybe the Chief, in a concurrence, I should say, I lean towards something like a tradition plus no coercion test. That is, they would say something like, well, there are certain, and I'm talking about religious symbols, I don't mean more broadly in Establishment Clause jurisprudence. They could say something like certain things are traditional, or I thought this was an interesting suggestion from the Solicitor General at oral argument, that it's not simply that this particular practice goes back all the way, but we say, well, is there something analogous that the framers would have understood? And that's the tradition we're talking about, not a specific practice like a cross, but something more broad. You would have a combination of, okay, this is traditional and no one is being coerced. And in those circumstances, there's not an Establishment Clause violation. That's what I might see. Mark?
Do you remember, Mark, when we talked a few sessions back in one of our Legal Spirits podcasts about Judge O'Scanlan's approach to tradition, that it's not necessarily the specific practice of legislative prayer, but whether it fits within the general tradition, right, with the overarching set of practices constituted by the tradition. It seems to me that if they go with the approach that you're describing, then it is a kind of an expansion of the town of Greece, the ambit of town of Greece, right? We've always said town of Greece, no, that's just for legislative prayer. That's just a carve out and so on. If that's the approach they go with, then it suggests that that approach has power beyond the legislative prayer context. And frankly, I agree with you that that is, at least of the categorical or big picture changes on offer, that's one of the more plausible ones.
I think so. I wouldn't be surprised at all, and I think that might actually be a very good approach, just for speaking for myself, if they did that. Okay, so now we've talked about Chief Justice Roberts, who also showed some interest in the coercion test, I have to say. Our listeners should understand he also asked a couple questions about that. Seemed like he liked that idea. Okay, so we've accounted for the Chief and Alito and Gorsuch and Kavanaugh and Thomas. How about the others? Well, I could see, based on their questioning and based on how they positioned themselves in other recent religion clause cases, I could see Justice Breyer and Justice Kagan writing separately in a different way, to say something like, well, okay, this cross is okay because it's old. It's there a long time. No one's objected to it. It has accreted to itself some non-religious meaning, but you can't do it anymore, right? New crosses wouldn't be okay, because this is a different country today, and we would no longer accept a sectarian symbol like this. I could see them writing in that vein, upholding this cross, but being very clear that you can't do it anymore.
Yeah, no, I think that's right. That's certainly what Justice Breyer suggested. That's what Justice Kagan suggested, that this is a unique cross. It's World War I. It's old. That looked like, that was from Justice Kagan. It looked like to me like an alignment with Justice Breyer's position in Van Orden. Justice Breyer said, the new stuff, the old stuff stays, but the new stuff is struck down because no more, right? He said, we're a different society now. And of course, look, that's exactly what's in dispute, is what kind of society we are and whom we honor and what our symbols are. And, for Breyer to say we're not that kind of society any longer, well, Maryland disagrees, right? They think we are still that kind of society. So it's a little difficult to understand exactly what he means by that. I think he thinks we're not that kind of society any longer, and he wants to nationalize that thought with a rule that would be along the lines of his sort of particularist old stuff stays because we were, and it's okay to recognize that we were, but new stuff, a new cross, wouldn't be constitutional. Yeah.
Yeah, and look, I think Justice Breyer wouldn't take this as an aspersion. I think in religion clause cases, he tends to be a legal realist, and maybe Justice Kagan is too. I think each of them understands that if the court were to say this 93-year-old World War I memorial must come down or must be transferred or something like this, I think there would not be a I think there'd be a negative popular reaction to that, which would not increase the court's legitimacy in the eyes of many people. I'm just speaking now, dear listeners, I'm just speaking as a legal realist. This is just something to consider. And I think that both Justice Breyer and Justice Kagan may see that this is not something they want this is not an issue that they want the court way out in front on. So that's another reason why they might write something like that. Okay, finally, we have Justices Ginsburg and Sotomayor. I think it's pretty plain that based on their questioning and based on their votes in other cases and their opinions in other cases, I feel fairly confident they will say this cross is unconstitutional under the Lemon/endorsement test because it is a sectarian endorsement. I think Justice Ginsburg at one point was incredulous that this could have any other meaning but as a Christian symbol. She got some pushback from counsel on that. And I think, Marc, maybe you would disagree with that. But I think that their position is the cross is a Christian symbol, and this is clearly an endorsement by the state, and therefore it has to come down. But I don't think they will get anyone else to agree with them on that. That's what I think. Marc?
Yeah, well, so look, just as since you say that I would disagree, I agree with if that's Justice Ginsburg's position and Justice Sotomayor's position, and in fact it was Justice Brennan's position in many of these cases that the cross is a Christian symbol. Of course I agree that the cross is a Christian symbol. It certainly is a Christian symbol. It is primarily a Christian symbol. And the only reason that we're talking about World War I and memorialization of the dead is because the cross is associated with the death and crucifixion and resurrection of Jesus Christ. So there's absolutely no question in my mind that those points are correct points. The question is whether those points, true as they are, render display of the cross unconstitutional.
Okay, then maybe, Mark, this is good. I've misunderstood what your argument has been for a few years. I thought your point was that the cross actually doesn't have simply a religious meaning, and it could have all other kinds of meanings.
Well, my view is the cross has multiple meanings, but those meanings all go together. So it's a little bit, from my own perspective, it's silly to talk about, is this just a cross-shaped object? Or is it a Christian cross? It's both things in the sense that it's a Christian cross and it's also a symbol of memorialization during World War I. It is that symbol because it was first a Christian cross. We are having these fights now because people object to the Christian meaning in ways that they didn't when the cross went up. And the question is whether that objection to a Christian symbol is sufficient to get something thrown out on Establishment Clause grounds.
Okay. Well, that's very interesting, Mark. So let's see what happens. This is now our second podcast on the case, and we certainly hope there will be a third when they actually issue the opinion sometime this year. And we'll see.
By the way, I should ask, what's your view? Since I've revealed myself with respect to my view of the cross, I should ask you in return, Marc.
Sure. Well, my view, I think I said it before, my view would be this cross is constitutional under the test that I'm suggesting these concurring judges, if they are concurring judges, would adopt, which is a combination of tradition and no coercion, that there is a tradition of this religious display. And it's true. Now, it is true that in American practice, most public religious displays are not sectarian like this for reasons that I've discussed in an article a few years ago. In America, our public religious displays tend to be non-denominational and non-sectarian. So we like the Ten Commandments. Ten Commandments we put up everywhere. But that being said, I would still say, on my understanding, these sorts of crosses are a traditional way to commemorate the dead. They go back a long way. They are not coercive of anybody. No one is forced to do anything with respect to them. You can just drive right by. And I would think that our Establishment Clause jurisprudence should have room for these sorts of displays. That'd be my view. And I personally wouldn't get into whether this is Christian or not Christian, whatever. I mean, of course it's Christian. There's no way it can't be Christian. But in my mind, given the tradition and the lack of coercion, that wouldn't make it an Establishment Clause violation.
Good. No, that makes sense. Just to point out, there was some questioning about whether there's a difference between Ten Commandments, monuments, and crosses, and I thought that was kind of interesting. It reminded me of this paper that you've referenced, or the arguments that you made in this paper about different kinds of symbols, and so maybe that's a way to distinguish. It doesn't seem to me that distinction is really going to carry the day here, but it is an interesting thing to think about.
Well, I think I better hurry up and send a copy of this article to all the justices before it's too late. So I'll do that. But you readers, you can find it. It's in the Oxford Journal of Law and Religion in 2012 called Crosses and Culture. So you can take a look. Okay, well, let's leave it there, Mark. Let's see what the court decides. For now, this has been another episode of Legal Spirits, which is our podcast series on cases and items in law and religion. If you'd like to listen to past episodes, please go to our website, lawandreligionforum.org. That's one word. Or you can follow us on iTunes. Until then, this has been Marc Movsesian, the director of the Center for Law and Religion at St. John's, with my friend and colleague, Marc DeGirolami. See you next time.